Good evening, ladies and gentlemen. Welcome to Pro Se USA. I'm John Arigoni, your host. Yes, we are live tonight, and I have some sad news for the viewers of Pro Se USA. William Foley passed away last November 27th, and it's been quite a while since we've been on, and that's part of the reason. And I've had my own problems, and we've lost one of our best fighters with Bill passing away on us. He knew exactly what was going on and how our government was working from the inside. I mean, he's been there. He ran for senator several times. He's dealt with many of our elected officials on a one-to-one conferencing basis because they used to ask him for information and his input on some of the plans and schemes that they were working on, and he would tell them how bad it was or how good it was or what he thought in any way, shape, or form about it. Now, Bill led the fight of Pro Se USA gallantly to the very last day of his life. He worked on everything that he possibly could have gotten done. He's told you everything that you need to know to defend yourselves, how your government is working against you, why they're doing it, what it's causing for problems to you and the rest of the world. And he gave up his whole life, the last 3 years of his life that he could have enjoyed, knowing that he was terminally ill, he gave to you people, hoping that you people would stand up and be counted. And I have to tell you, you failed him. You failed him miserably because you did nothing for yourselves. You were hoping that his combination with me was enough to cause a change with our government, but you have to realize that two people alone cannot change a government that's run by a well-organized minority association that is connected to every association that is running our government through interlocking boards of directorships. Now, Bill stated that several times. I've mentioned it a few times. And it's something that you all have to stand up and make the change happen with. You have to be counted. Now, I'm working on a letter that we need to send to our officials that lets them know about the civil action we filed, even though I'm sure they already know. It lets them know that we understand what the Constitution says when it says that we have a right to equal and proportionate taxation, that it is a mandate that everyone pays their fair and equal share of an estate interest on real property. We understand that a duly recorded mortgage shows joint ownership of that property, and that the mortgagee, the holder of the mortgage, owns that part of the property until you pay them off. We have to let them know that we understand the law, General Law 59, Section 12, requires the assessor to tax the mortgagee on their duly recorded mortgage, and then to tax the mortgagor on the remaining value of the property. Well, they haven't done that. And they haven't done that for over 100 years. But the law requires them to do this. Now, the problem with our court system, all of the attorneys who have practiced law generally have went to closings and represented a buyer at a closing, showing the mortgagor would be to sign the contract where it says we would pay all the taxes at the last minute. At the 11th hour, that part gets put in front of us, and it was never presented to us when we applied for the loan. Now, every attorney that did this violated the fiduciary duty they owed to their client, because they should have said to their client, don't sign this until they take that clause out of there, because that clause requires you to pay the taxes that the bank is supposed to pay. Now, if you did that, if you went to the closing and you said to the bank, look, I'm not signing until you take that clause out of there that says I'm going to pay all the taxes because you own part of the house, they would say, we can't give you the loan. Now, I call that extortion. I don't know what you call it, but I call that extortion. That's predator lending. That's against the law because public policy forbids it. Public policy requires equal and proportionate taxation. Now, Bill knew that. Bill was fighting for it. Bill asked you to help him. Bill needed the help, just like I need the help. I can't do it alone. I'm a single person. My vote doesn't count. Quite frankly, according to the last election, none of your votes count. They can do what they want. They run the election process. They control every part of the government. And you don't have any say about anything. Oh, you can talk amongst yourselves. You can bicker in the kitchen. But it's not going to help. The only way you're going to get anything done is if you all stand up and be counted at the same time and you let them know in force that you are together on it. They have to see heavy numbers before they start behaving like they're supposed to behave. They're not going to give you justice in a court where every attorney who became a judge is guilty of misrepresenting you and denying you the right of his judiciary duty to protect you from a fraud in a contract. That's what's been happening. So I'm working on a letter that I want to write, and I'm getting it partly done now. Let's see here what we got. It'll be a letter to the governor, to our state Congress, Lieutenant Governor, Secretary of State, the Attorney General, the Treasurer, and we should copy it to the U.S. Congress, the U.S. President, and the U.S. Attorney General. And we should let them know that we want to bring to our attention that the banks and the assessors and the closing attorneys with the knowledge of the Commissioner of Revenue who allowed the assessments that the assessors levied against you and your property have committed contract fraud and tax extortion in a conspiracy against every mortgagor in the state of Massachusetts. Now, we know that this is happening throughout the United States, that they have done this to everybody in the country, but we have to deal with Massachusetts. Now, we have to let them know that under General Law 93A, Fair Trade Practices Law, the Attorney General is supposed to protect us from any kind of violation of contract fraud or any business fraud under the 93A law. Okay, now we have a problem with our officials because they've been paid to do something other than what they're supposed to do. They gave a special privilege beyond that of the general public to the banks. We have to tell them it is their responsibility to see that the Attorney General does the job that he's supposed to do, described by law, to protect us from such a fraud. Now let's see. Now this act has been done against ourselves and every other homeowner in the state with a duly recorded mortgage contract that showed that the bank had property interests. Now we have to let them know that we have this case pending and that the court has been handing down judgments without jury trials, in closed-door, star-chambered hearings, denying due process and equal protection of the law, which leads to the fact that the attorneys are involved in the case and that the judges who were attorneys who were appointed are protecting the fraud in order to continue the fraud so that others may be taken for a ride. We have to let them know that everyone in the state has been affected and irreparable harm has been caused, and that these people have to make some sort of restitution, and primarily they have to stop it. Now, I don't expect that they're going to be able to pay us for all the damages that they've committed us to for the last 150 years. So the best thing that we can ask for is for them to stop taxing us on what we owe to the bank. That's a debt, and there's no provision in the Constitution whatsoever to tax us on our debts, and that's what we have to let them know. Now, the tax assessor, with the tax collector, has been demanding payments from the mortgagors in support of a contract that commits a violation of public policy with threats of fines, fees, and penalties, and foreclosure. They'll take away the house if you don't pay the taxes that the bank owes. Now, General Law 5912 states in Section 2 that a mortgagee with a duly recorded mortgage is a co-owner of the property and therefore has a state interest in the property and must be taxed accordingly. They have not been enforcing the law. Now, that law supports public policy of equal and proportionate taxation, and no other subsection of that law was necessarily needed in order to protect public policy. And then we have to ultimately let them know that it's their responsibility to protect us from these crimes and hold accountable every judiciary member in the court that has violated a person by foreclosure or by a tax taking, and every one of them that has denied us due process in this matter. Now, when I finish this letter, I'm going to ask you to join me in sending it out to them. What I'm going to do is I'm going to get their addresses. I'm going to format the letter. I'm going to put it up on the ProSay USA site. And I'm going to expect those of you with computers to pull this letter down, copy it, pass it to your friends that don't have computers. Ask everybody that you know to send in these letters. Everybody needs to send one in, and there's going to be like maybe 10 copies to different officials in order to make sure that they are aware that we are here and that we are angry with their violating our civil rights and that we want them to do something to stop it. Now, I cannot continue doing this by myself because I'm not getting anywhere. They ignore one person. So if you want this to happen, you got to get up off your couches. You're going to have to do something. And seeing as you're all lost at an angle of where you're going to come from or what you can do, this is the thing that you should do, because it's not going to cost you an arm and a leg. It's an act that will at least get their attention. If we get their attention, we may get some sort of justice. If nothing, at least we might be able to get them to stop taxing us on what we owe to the bank, which is probably the best we can hope for. Now, it's going to be hard to get them to go against the banks with all the money, because that's where they're getting their funding, and some of them probably own shares in the banks, and it's going to be very hard to cut that wire that they have in that chokehold over us. But the only way to stop it is to take some action. One way or the other, this is going to end pretty soon. I mean, it's either I'm going to stop because you people don't want me to do anything, because you're showing me if you don't do anything, you don't want no help. And I can't help you if you don't want to help yourselves. You got to do something. Now, in the meantime, they filed motions in the case to dismiss the case and have the people who filed the complaints, there's 20 of us on it, specifically me thereafter, pay all their legal fees, which whether they get a judgment for it or not, they aren't going to get, because I just simply will not accept a judgment from a court that is illegitimate. The court is illegitimate. So I filed an opposition to their motion, and then I filed my own motion to dismiss without prejudice and without a finding, so that we can approach Congress, the United States Congress, to hold the courts in the state of Massachusetts accountable for violating civil rights of the people and partaking in a contract fraud and conspiracy for conspiring to obstruct justice and for denying the right of trial by jury. Every court in this state has violated every person in this state, because they are all associated and they all have an interest in not allowing us to win our case and stop them from taxing us on our debt. Now, the facts are this. In my motion, these are the facts the way I wrote them. On April 26, 2000, the plaintiffs filed a citizen suit class action, which brought forth an assertion of obstruction of justice against the judiciary. And on May 19, 2000, the plaintiffs filed a third-party complaint that included the entire Bar Association as defendants, which has in effect made all judges in the Commonwealth of Massachusetts defendants themselves. Ergo, only a jury can make a judgment in the instant matter, and judgments ordered were prejudiced by defendant judges, administering so-called discretionary function in order to deny jury trial due to the subject matter of the complaint and the defendants named therein, which includes the members of the Bar Association and specifically the judges on the bench. Fact. The civil action was signed by 20 citizens similarly situated and labeled a class action in its title, stating in count 2 that failure to assess according to General Law 59, Section 12 would inflict irreparable harm to the plaintiffs and the plaintiffs' class. The court knows when 10 or more citizens file the same complaint and make such a statement that it is in fact a class action, and is mandated to inform all affected members of the class, which means everybody in the state that has a mortgage. However, this court, with intent to obstruct the civil right of trial by jury in all civil actions concerning real property, failed in its duty to identify the class action to protect itself and other defendants due to the subject matter of the complaint, and the defendants named therein, which includes the members of the Bar Association and specifically the judges of this court. Fact. In consolidated cases 0128 and 0909, that's a case that I have going with the City of North Adams and the lead paint law and the devaluation of property, and it's involved with this as far as taxation is concerned, is a civil action running for over 13 years. Has been obstructed by the court, had an appeal pending. It's been pending since February 2001. It's been over 4 years. The court and its officers have by intent failed to assemble the record. They don't want to hear nothing with this. They don't want a jury seeing it, and they can't stand the truth. They are obstructing justice due to the subject matter of the complaint and the defendant's name therein, which also includes the members of the Bar Association and specifically judges of this court. Fact, a motion to the appeals court filed by John Arigoni requested that the lower court be ordered to assemble a record in those consolidated cases. It was filed on January 14, 2003, and denied by a spewing of words, no action necessary, and no notice of assembly will issue, or actually it says, and notice of assembly will issue in due course. That's the court saying due course can take 100 years. In due course. It's been 4 years. What is due course? Due course is whenever they darn well feel like it. They have no due course. They have their own timeline, and their timeline is to deny people entrance to the court when their members are directly related to the crimes committed, or when they're isolated as and identified as defendants. Now that's what they did to Bill. Bill's had cases that have been running since the early 70s. And they waited for him to pass away, and now that he passed away, they can throw those cases out of the file. That's what they want to do with my case. That's what they want to do with our civil class action. They want to let it stay there and stay there and stay there until the people who are capable of doing something and writing paperwork disappear, so they have nobody to oppose them. And they call it due course. The results, an obvious obstruction of justice by both the Berkshire Superior Court and Appeals Court, is due to the subject matter of the complaint and the defendant's name therein, which includes the members of the Bar Association and the judges of this court. Now, that phrase is at every ending of these facts, because that is the key factor. That shows that they have co-conspired with the banks, the assessors, the attorneys, the Commissioner of Revenue, and every other state and legislative member who has allowed this criminal, inhumane act against the people of this state. Every homeowner has been violated. Fact, an affidavit of futility was filed in consolidated cases. And on November 2nd, 1999, answering the asserting that obtaining a justice from the courts of the Commonwealth is in fact a futility. Now, they didn't give me a docket number on that entry because they didn't enter it into the docket. I filed it. I've got my mail-in receipts. I can show that I sent it to them. But justice can't be had from the court because they made it a futility. Everything is ridiculous in the way that they handle it. They send you off to the mountain looking for a bucket of blue steam, and they expect you to bring it back knowing that you can't. They give you the rules. This is what I'm saying. It correlates to the rules. They lay down the rules, and for every rule that sounds good and looks good, they have another rule that overturns that rule. So if you can meet what the rule requires, they got another rule that says you failed. So no matter what, whether the law, the same with the law, when they write laws, they set these laws up. They look great on the surface, and if they actually do the job, then they got another law that overturns the law that you're using. That's how they get away with using discretionary function in the court. And for every good law, there's 10 bad laws. Okay, so obtaining justice from the courts of the Commonwealth of Massachusetts, in fact, a futility, due to the subject matter of the complaint and the defendant's name therein, which includes the members of the Bar Association and specifically judges of this court. Futility is relevant to the instant matter, which is our civil class action. Fact, as a result of the obstruction of justice in the consolidated cases, a civil rights complaint was filed by John Arigoni against the Superior Court Judge Thomas Curley, against attorneys Elma Arlos, Stanley Cook, the court clerk Deborah Capeless, and the court reporter Lance Boardman, which is currently under appeal and in fact implicates all other associated court officers and the Berkshire Superior Court, rendering any decision invalid as the court is of incompetent jurisdiction and monopolized as a defendant by the defendants. Fact: on February 20, 2004, the plaintiff sent a request to the moving defendant party, giving copy to all defendant parties, explaining why an answer could not be made. At that time, I was kind of ill, and I was going through surgeries and so on and so forth, so I wasn't able to answer them. And then I answered this. This was an answer to memorandum to dismiss. Now remember that. The first, let's see, statement of facts made by the defendant's memorandum in the instant action in part is true. However, the defendants failed to state that the final judgment ordered was prejudiced by a defendant judge, as were all prior judgments, and all subsequent judgments and orders of related cases for foreclosures due to the subject matter of the complaint and defendants named therein, which includes the members of the Bar Association and specifically judges of this court, are invalid. Okay, now the argument that I sent in. The above stated facts certify a futility where there are no meaningful hearings, only judgments handed down by co-defendant judges. No meaningful transcripts can be had. I've sent for transcript and every one of them has been altered that I've received. I sent away for tapes and the tapes were changed. They altered them, they changed some of the words, they took parts out. Not one of them came back the way it happened in the court. Therefore, without meaningful transcripts, none can be requested. The fact that the appellants would have to file an appeal with defendants gives rise and meets the standards of excusable neglect. They were asking for a dismissal on the grounds that we failed to send in our appeal. But it was senseless to send in an appeal based on the fact that the defendants would be receiving it. So that rises to the standards of excusable neglect within the meaning of the Massachusetts Rule of Appellate Procedure 10C. Based on error at law where the defendant judges made rulings to deny justice and caused the appeals process to come into play as an obstruction of justice, demonstrating good cause as to why the plaintiffs could not comply with Rule of Appellate Procedure 9C or produce and cause the existence of a meritorious appeal, because no such appeal would be considered meritorious. No matter what we wrote, they would deny it. Okay, so no such appeal would be considered meritorious to a defendant judge based on the prior behavior. And then it relates to excusable neglect of a case of Marcina and Pappet, and good cause through a case of Westinghouse Electric Supply and Healy Corporation. Now what that simply says is we can't present you an appeal because you are the defendants and you cannot be handling this case. We have to have an independent court. Pursuant to Supreme Judicial Court Rule 309, Canon 3, C, 1B, any judge who knows or reasonably should know that he is a party to the complaint is required to withdraw from the presiding over the action. And in the instant action, all judges are defendants. Therefore, all judgments, rulings, and orders are a result of error at law which the plaintiffs are not responsible for and demonstrates extenuating circumstances and is reasonable cause for plaintiff's failure to comply with the rules on the grounds that the plaintiffs are in fact facing a futility. Judgment in a hostile court, in fact, facing a futility judgment in a hostile court run by the defendants. Hawkins versus Hawkins, 397. That's another reference to a case based on the extenuating circumstances, which is why we didn't file an appeal. It's not necessary. We want a jury trial. That's what we should have had in the first place, and there should not have been no such thing as a demand or a need for an appeal. But they made judgments in closed doors hearings, in a star-chambered hearing, and we didn't have access to the court. Now, the civil action that we filed implicates the court and all the court's officers, naming them as defendant association members, and demonstrates unique and extraordinary circumstances leading to cause plaintiffs' failure to comply with the rules on the grounds that the plaintiffs are in fact facing a futility and falls within the meaning of Massachusetts Rule of Appellate Procedure 10C. Plaintiffs assert the complaint brings forth circumstances that are unique and extraordinary that involve the obstruction of justice manifest within the court, giving rise to futility by error at law, which has reduced the filing of an appeal to be a hopeless act of desperation to acquire justice from the very defendants that have collusively acted to violate the law, the Constitution of the United States, the Constitution of the Commonwealth of Massachusetts, and the civil rights of the plaintiffs in the first instance, allowing and joining into a conspiracy of contract fraud with the lending institutions through the unlawful wording of a statutory mortgage form. That's what we're facing. In the third-party complaint of the incident action, all of the members of the Bar Association were named as defendants, and the rules of the court were contested as an obstruction of justice. The orders of the final judgment were in fact made by a defendant are invalid, as are all the rulings made against one or more of the plaintiffs in related foreclosure actions. Where defendant knowingly went to the land court for judgments while the incident action had been pending, contesting the validity of mortgage contracts. Further, the incident action is an unprecedented case, and therefore, on its own merits, demands grand jury action. We need congressional action with a grand jury to investigate the courts of the Commonwealth. Now, that's what we have to do. And in our letter to our elected officials, that's what we have to ask. Now, if anybody wants to give a call, we're live tonight at 664-4408. And I guess now what we can do is talk a little bit about some of the current affairs that Bill and I had mentioned to you, how things were going and how bad things were going to get. And of course, you've seen on the news that some of our military people, our troops, have committed abusive acts against the Iraqis. They've taken pictures of it. They're all smiles about what they're doing. They're doing exactly what our government has been complaining that Saddam Hussein had done. Torturous acts. Criminal acts. But that's okay, because these are not prisoners of war and they're not entitled to protection of the Geneva Convention. These are detainees. A play on words makes it okay. Now, when I was a foreman at the paper mill, if one of the people that worked underneath me did something wrong, I got the pink slip for it. I got the blame, because I was in charge. Our commander-in-chief is in charge. He sent these people over there. We all know that he started this war because he was beating on a vendetta. He wanted to get even for his father. He sent these people over there. He's the commander-in-chief. He's ultimately responsible for what they do. Bill told you George Bush was a cowboy. We told you the day before 9/11, which was a Tuesday. We told you that Monday night to get ready. There was going to be a lot of things happening. There was going to be attacks here in the United States. We didn't know exactly when, but we knew that it was going to happen because of the way things are going. And boy, were we surprised the next day when it happened the next day. I mean, we expected it, but it's like anything else. Even if you expect it, when it happens, it's still a surprise. Now, we all know that George Bush didn't get properly elected. He was appointed by the associations, the gangster government associations, the members of the Bar Association, in league with the two political party associations, the Democrats and the Republicans. One's good cop, one's a bad cop. One says this, the other says that. They party in the back room. What are we going to plan for tomorrow? They talk to each other and they give it to you tomorrow. Can we impeach a president that was never really properly elected? George Bush really needs to be removed from office. He has placed this country in extreme danger. If you think Iraq is bad, wait until you see what happens here. Those people over there were counting on the United States to protect them from the kind of cruelty that our armed forces are inflicting on their people. Because they're detainees. They're not prisoners of war. Remember that. That's a crock of bull. I'm ashamed to say I'm an American. A lot of the countries in the world are not too happy with the United States anyway. But did we have to go show them that we're going to be torturing their people? What we have in the United States is an associated gangster government. A two-party, bipartisan, parliamentary-type oligarchy screaming democracy and practicing hypocrisy. And we are slaves to that government. None of you will stand up and fight. Not one of you has done anything to come up here and fight with this case, to make any of those people out there that are running your government and ruining your lives stand up and take note. And every one of you need to do this. Every last one of you. I understand you have to work 2 and 3 jobs because you can't afford to meet your mortgage or pay their taxes or put food on the table for your children or buy clothes, get shoes on their feet. The cost of living is going up and up and up and up while your wages go down and down. The cost of fuel is going up. The cost of home heating oil is going up. The cost of natural gas is going up. How do you like that? Natural gas, they get it out of the ground for free. We paid for the utility lines and the service 10 times over. But you're paying for the gas too. When are you going to wake up? Now this government of ours, under the leadership of George Bush, declaring freedom for the Iraqis, no more torture, is torturing them. Declaring we're going to set up a two-party democracy for them, it's a hypocrisy. Do you think they really want this? Do you like your government? Are you enjoying the fruits of this kind of freedom? Or are you paying for this kind of slavery? I think you're paying for slavery. These people take raises from our treasury and they deny your children good schools. They deny you medical protection. They're taking away your Social Security. And you've been paying for it for 40 years or better. And this is the kind of mentality we have of a government. We have a phone call, so we're going to take that. Go ahead, caller.
Wondered what your take is on the common law jury. That was taken away from us 100 years ago, wasn't it?
To be honest with you, I couldn't tell you because I haven't really looked at things like that. I've been working with the case and more strictly with what we're dealing with as far as the taxation issue.
So,
but yeah, what we should have primarily on the first instance, we should probably have one person filing a case against the other person or against the other party, whoever it may be, and they should set up a date, do a pretrial conference right away, see what the issues are, and bring it right to jury trial. And then if something else comes up, like new evidence that should have been entered that wasn't readily available, then what they would have to do is petition to another jury on an appeal. But there should be no rulings by any judge whatsoever.
well, I was wondering why they refer to 49 states out of the 50 as being common law states when we're not under the common law system anymore. We're under statute law, that's what they say.
Right, we're under statute law, but common law is like with marriages and stuff. Like if you live with somebody in Massachusetts for 7 years, then they consider all the property between the two people living together for that length of time as partners, that they are married. That's like what common law means for that.
That's true, but when the Constitution was formed, we were under a common law jury system. I don't think it had anything to do with common law
marriages, no.
Wife or common law marriage.
No, I don't think so either. Yeah, well, you see, the thing is they changed everything to suit their needs. And when they have one law, like, let me see here. How did that go? General Law 58, I believe it is. That's the law that protects our municipal workers from suit while acting in the scope of their duty. Now, with the lead paint law, they violated civil rights of the people. When I filed my complaint against the city of North Adams for issuing those certificates of occupancy, and then the city of North Adams contracted with the visiting nurses to test the children in the houses that I rented to children with after I had those certificates and found a child had lead poisoning. Well, when I filed that complaint, the legislature went to town and wrote an addition, or an amendment, shall we say, to General Law 58 to deny anybody the right to sue the municipalities for issuing those certificates, irregardless of whether it was right or wrong. So when they want to change things, they change it for their own benefit. So that's probably the answer to your question is why did they do away with it? Because it wasn't convenient for them.
Well, do you think we'd be better off to get back to it?
I think we would be better off to just take all these laws that they wrote and throw them right in the trash and start fresh right from the basic line of the Constitution.
Yeah, but you got to be a little more practical than that, haven't you?
Well, I realize
Go ahead and throw all those laws out. They'd never allow it. How do you put a chink in their armor so that you can do something about the damn thing?
Well, that's the whole thing. They've made it so bad that it's almost irreversible. It's irreparable harm. These people are incensed on beating on the general public using the law as a weapon, and they were very effective at it. They know what they're doing. They know how to do what they're doing. They just don't realize that they're destroying not only the security of the United States, but what they're doing is they're undermining the ability for man to exist on this planet, because eventually it's going to be total chaos if they keep doing what they're doing. And I think, quite frankly, they've almost gone to the point of no return.
So, in other words, what you're saying is that our case is hopeless.
As far as
unless the people be a groundswell of grassroots.
Exactly.
But
we have to be.
That has to come spontaneously, doesn't it, or more or less?
Well, it has to start somewhere, and that's why I'm saying once I finish this letter, I'll come back on live again. See, I'm not going to be able to come back on until after I get that done, because I got a few more papers that I got to write and everything. But once I get this letter done and hoist it up on the internet, I'll come back on live, and that's where things start. Somebody has to start somewhere. And if everybody grabs this letter and sends it out, then we've got at least a notoriety of a situation that they have to look at, because so many people will be sending it to them. You see what I'm saying?
Yeah, that's right.
If they don't get any information, or if they only get a letter from one or two people, it's not going to do any good, because they're going to go in the trash, because it's not something they want to see. But if they get hundreds of letters, and these letters keep continuing to come every week, then they're going to stand up and take notice of it, because pretty soon they're going to have a problem going through the hall.
How about a general nationwide strike?
Well, I'm all for that. I'm all for that. I'm all for everybody in this country should say we're not paying any more taxes. We're not going to support any part of this government until you people stop what you're doing. You people have to pay us back all those monies that you stole in raises that we didn't never give you, that you made laws for your own self to take. And you got to put the money back into our Social Security system. You got to stop sending money overseas to take down countries and set up two-party democracies that are hypocrisies, and put the money back into the schools so that our children can learn some real truth. Or we're not going to give you nothing. We're not going to work, and we're not going to let our employers give you our money. I'm all for that. That's 100% the proper way to go. Absolutely. I mean, that's passive, but it's something that they have to, that they will feel. You know what I'm saying?
Absolutely, if you get enough people to embrace it.
But that would be awful hard, because right now the government has everybody so oppressed. Like I said, they're working 2 and 3 jobs. The kids are home alone watching TV. They're being spoon-fed garbage, made to believe that the government is acting so righteously it's incredible. Made to believe that wielding a gun and shooting people down the hall and up and down the street is okay, and they're being made to feel immune to the morality of death, especially if they're the cause. So the way this government is behaving, that's the only way we can stop them. We have to take the money and the control and the power out of their hands one way or the other. And the safest way, of course, for every person is to not give it to them, to not allow them to take money from us. But like I said, the biggest problem is everybody's got to work 2 and 3 jobs in order to survive, and everybody's still starving. There are people that are starving here in this town, right in this city, because they don't have enough money of their own. They don't have a good enough job. Food stamps don't go far enough. A lot of people are right on the edge of being accepted for food stamps, but they make 2 pennies more a year than what they're supposed to. So that means they aren't entitled to any of it. I mean, they do this with all of the government programs as far as anybody who needs help. They say, okay, you can make so much money, but after that, you can't get any of our help. And most people are $2 and $3, maybe even a couple $100, maybe even $1,000 more than what their program guideline states. But their expenses take that money away from them faster than the people who didn't make that much. You see what I'm saying?
Oh, absolutely. I agree with you.
So they really haven't taken into consideration the individual need of the families, only their basic structure. Because For them, it was a benefit. They get to take all of this money out of our state treasury for that program, and they pay their employees and deny the people who could get the program, who really need it, from being able to obtain the money, so they use the money for themselves as pay, which constitutes working the program. Only the program's not really working. And that's what they do with almost all their programs. With every program that they have.
Let me interrupt you if I may, sir.
Sure.
Why do the people, why are they able to snow them, so to speak? It's a snow job they're doing on them, right? Doing on us. How do they get away with such a...
How are they getting away with it? Well, first of all...
I mean, it doesn't make any sense when you take all the work out of the country and send it to some other country, and they tell you that it's good for you, and people believe it.
Well...
There's got to be something other than...
Nobody believes it. Everybody knows different. The fact is these people who made us pay to relocate those companies are the people running our government. And they are doing that because they're hedging their bets, so to speak. They're moving these companies out to other nations so that when the crap hits the fan and the United States becomes the fall guy, where the rest of the nations sanction the United States, they've got a place to run to. And they're still going to make big money. Okay? That's what the real reason for that World Free Trade Act is. It has nothing to do with making things better for us, because it made things worse. It undermined our economy.
Yes,
it took away our production jobs.
You've got people that believe that it is a good thing.
Well, they've got them brainwashed. They've
My
conditioned
question
everybody
is,
to accept these things.
I can't understand how you can brainwash that well unless you're using some kind of a method to it.
Well, a lot of the people that are accepting it are older people who are on Social Security and getting their share, all right? But the next generation ain't going to get their share. So the problem is the activity is 10 years ahead of, or 15 or 20 years ahead of the actual results. That's the way our government works with their plans. They plan 10, 15, and 20-year plans that affect people 20 years down the road, and right now the people don't see it. So they let it happen because it's not affecting them immediately. You see what I'm saying?
Yeah, but this shift in the work to foreign countries, I mean, that's affecting people right now.
That was ludicrous.
Plenty of them.
Well, they started that how many years ago? 10, 15 years ago, right?
Yeah.
All right, now it's killing us. It ruined our economy. They keep boasting how good our economy is, that money spent in buildings and construction is up from last year. Of course it is. Why is it? Well, when last year plywood sold for $17 and it's selling for almost $60 now, you can see why. And why is that? Because they took all of our material and sent it over to Iraq. Okay?
Yeah.
So the industry didn't do any better. They're just getting more money for the material, and it's costing us an arm and a leg, and we're all in worse shape than we ever were in. This is the problem we have with these people. And they're doing okay because they're the ones receiving the money.
Well, okay. This thing of we went off the gold standard, right? 1932 or so.
And that was a mistake.
Well, maybe, but they promised to give $1 of gold for every paper dollar, right?
Mm-hmm.
But did we actually have that much gold, or did we just promise to it?
Just promised it.
Well, that's what I thought.
It's like their bonds. They promise the money in 20 years, but what happens if the government fails in 20 years? You ain't getting no money from them. They'll just write a law saying, well, Treasury is bankrupt and we can't afford to pay you, so we're going to give you 2 cents on a dollar. Take it or leave it. And they can get away with it because they've been getting away with everything.
Well, it used to say pay to the bearer on demand.
Right.
But it seems to me that we never had enough gold to back every paper dollar.
We didn't. And there'll never be enough money to back the paper dollar. So it's the paper dollar itself that they're basing the value on. There's nothing to back it.
Except our production and our production backs the money, doesn't it? Not gold. Gold is worthless actually, except for a commodity.
Right. Well, it's used for many, many things, and it does have a lot of value. And gold will be going up. In a couple of years, gold is going to be about $600 an ounce, between $600 to $1,000 an ounce.
Yeah, but what the hell good is your gold if there's nothing to buy with it? What I'm trying to make
That's right. We aren't going to have anything here. That's exactly right. We've told you before that we're going to have a problem with food and products and distribution and everything else, and we're headed that way really fast. And what we're going to have is like Iraq has. We're going to have total chaos here. And if we don't stand up and stop these people, if we can't get President Bush impeached, and if we can't correct our crooked officials and stop them from running the government as a two-party, bipartisan, parliamentary type hypocrisy that screams democracy, we're going down the tubes.
Well, what grounds would you impeach him on?
On the grounds that the troops that he sent over there sodomized those Iraqis that were in captivity. He's responsible ultimately for violating their rights and their persons. It's immoral.
You can't expect a commander to be responsible for every single incident, can you?
He sent them over there. We had no right being there in the first place. We should have never went over there. We should have never started this war. There was no weapons of mass destruction. Yeah. He sent them over on a vendetta. He's responsible. Nobody else can be held responsible. He's the one that ordered the war. He's the one that caused it. They're acting under his command. He's guilty. Simple as that. He's the commander-in-chief. They are the soldiers. Those are his troops. He's responsible. They wanted to get Saddam Hussein out because he was torturing his people. This ain't any better. Well, anyway, that's about it. We got 1 minute to go here. Are there any last questions?
If you do a little research on the common law system, I kind of like to get your response to it.
Well, what I'll do is I'll finish up the paperwork I'm doing. This will take 2-3 weeks.
Well, whatever it takes.
Yeah, and then I'll take a look at it and see what I can't do when I come back on. Maybe I'll have an answer for you, in respect to what my thoughts are on it. Yeah, I'm sure it was a lot better than what we got now. Right now we got a dictator court.
Good evening then, sir.
Well, thank you very much for calling. You have a good night. Well, ladies and gentlemen, that's about it. I hope you sit down and think about it. Think about acting instead of sitting on your couch. I'll write these letters. I'll present them to you. And if you don't want me to continue, just don't bother collecting them and don't send them out. If you want me to continue, if you want my guidance, my help, I need your help to do it. Can't do it alone. I won't do it alone. It's time for you people to act. It's time to straighten out this government. That's it for tonight. Thank you for joining me. And say a little prayer for Bill Foley's family. And maybe if you see them, let them know. And send them, a few best wishes. Have a good night. And we'll see you next time I come on.